Good day. I'm Jeff Clayton. I'm the Executive Director of the American Bail Coalition. Thanks for taking the time to watch our series, 2021, an update on bail reform. In this part 3 of our series, we look at the issue of preventative detention, the history of preventative detention, and how preventative detention interplays into the no-money bail system. It's often heard today that there isn't a right to an affordable bail. And what does that mean? That means that a bail could not serve to detain somebody in jail if it was not posted. Today, the law requires that a judge impose a bail that's otherwise not excessive under the Eighth Amendment, and that has sufficient sureties under the various state constitutional provisions. If somebody doesn't post a bond that was set by a judge that meets those criteria, that bond can serve to detain somebody in jail. It's often argued that judges just do this intentionally. They willy-nilly assign high bonds and don't follow the law to detain somebody in jail. The argument that bonds are too high and is tantamount to preventative detention is called sub rosa detention, meaning sleight of hand. A judge who does not have the power to detain simply sets a bond so high that a defendant cannot meet it, thus affecting the purposes of detention, rather than following the law of Stack versus Boyle and calculating a bail that's reasonably set to guarantee the appearance of the defendant at trial, and no higher. The current movement of preventative detention, however, is to recognize that sub rosa detention is a bad practice, that judges should not be intentionally detaining people with bond, but should be setting bonds that meet the constitutional standards. The current movement would legitimize sub rosa detention by suggesting that we should have preventative detention in all cases. In other words, we don't like the back door that judges are using to keep people in jail pending trial by setting bonds that are too high. And so, instead of getting at that process, what we're going to say is, no, we're going to use state constitutions and what I believe is a wrongly decided decision of the US Supreme Court to legitimize this process throughout the United States, rather than fighting back against what we think is a wrongful process. So when it comes to the no money bail system, if there's no mechanism for detention, what would that mean? It's very simple. Everybody would get out for free. And maybe there would be some pretrial supervision in some jurisdictions. And so in no money bail systems, there's always a call for preventative detention and a fight over what cases and classes of offenders should be detainable, and whether giving the government the power to detain somebody they're prosecuting absolutely with no bail is good public policy and prevents crime. This is essentially what happened in New York, because New York does not have preventative detention, has never had preventative detention. Limiting the crimes for which bail may be imposed, but not offering prosecutors the alternative of preventative detention backfired in the state of New York. And the governor, for that reason, overrode the system through the budget process and reversed it in large scale. Preventative detention, which is the power to deny bail, which was first codified in the Bail Reform Act of 1984, was held unconstitutional by the US Court of Appeals for the Second Circuit in an opinion read by Judge Amalia Kearse. Of course, it was ultimately affirmed by the US Supreme Court in 1987 in a split 7-2 decision in the United States versus Salerno decision, which for the first time held that a prosecutor could move for and achieve detention of an individual pending trial, absolutely, with no possibility of release. However, under the Salerno decision, only those who are specifically eligible for preventative detention may be detained pending trial. Prior to the US Supreme Court's decision in US versus Salerno, the federal constitutional right to bail was viewed as absolute. In other words, a bail must be set in all cases, except capital cases, when the proof was evident and the presumption great. And that has been the constitutional tradition in this country until the Salerno decision in the Federal Bail Reform Act of 1984. The original Judiciary Act of 1789 had bail by sufficient sureties. The Northwest Territories Act had bail by sufficient sureties. And so the idea that we had this right to bail that cannot be denied by the government was enshrined in our tradition and was enshrined by the same writers of the Constitution who wrote the first Judiciary Act of 1789. In fact, the ACLU and some of the most learned academics at the time in the early 80s, practitioners of the generation like Professor Daniel Freed, vigorously opposed the Bail Reform Act of 1984, arguing that the personal surety system, while not perfect, was a better alternative to preventative detention. And it's often thought that bail agents are part of this, quote, cash bail system, which is false. A cash bail system is a creation of statute. A commercial bail bondsman acts as a personal surety within the personal surety system as contemplated by our laws and by our tradition. At the time, the ACLU and others argued that there was no way even with these new fancy computers, to predict accurately human behavior to a constitutional certainty that locking somebody up to prevent what may happen in the future was constitutional. And of course, many states have a more expansive right to bail than the Eighth Amendment, as I mentioned, that all defendants are bailable by sufficient sureties. Salerno does permit states via their constitutional provisions or state statutes to define what cases or defendants would be eligible for preventative detention. And this is indeed how the federal system operates. Salerno, however, requires that there be some basis to include or exclude crimes or circumstances, with the Supreme Court having pointed to the evidence that Congress had before it, that these particular crimes required or at least allowed prosecutors to seek detention. Oftentimes we see general grants of preventative detention, but that doesn't meet the requirements in Salerno. There has to be some reason that these people are included and these people are excluded. In addition, clear and convincing evidence of flight risk or danger to the community is required, as is proof that there's no other release alternative that will be adequate from the perspective of guaranteeing appearance or guaranteeing the safety of the community. And this requires a hearing where the prosecutor has to put on clear and convincing evidence, a contested hearing, which is important to point out. Let's get some facts on preventative detention on the table. Systems of preventative detention are expensive to implement due to the burden of hearings and the heightened proof required of prosecutors in all cases where somebody's going to remain in jail. There's only one option in a system of preventative detention. That's preventative detention or not. There is no bail, which brings me to something we can discuss later, that there's a possibility of maybe a hybrid system that would work a little bit better than a system of pure no money bail. Systems of preventative detention do tend to over-detain in time, and I think the Federal Bail Reform Act and the federal system is the prime example of that. Of course, it was passed for the same reason that one might be considering the no money bail system today, that there's just far too many persons being held in jail pending trial due to money bail. And of course, in the federal system in 1984, 24% of those arrested for federal crimes were held in jail pending trial. Now that we've transitioned to a system of preventative detention, that number is up over 70% today, meaning we've tripled the rate of pretrial incarceration. And indeed, detention is the norm now, not liberty, which is what the Supreme Court said in 1987. And of course, Justice Thurgood Marshall predicted it all in the dissent in the Salerno case. Why does this happen over time? And the answer is because every time somebody gets out for free, there's pressure on the system to detain. When we have preventative detention, we don't need to get into bail, guaranteeing appearance, the appropriateness of bail, the amount of security required. We simply lock somebody up and throw away the key. There's more pressure to lock somebody up and throw away the key, the more crime there is, rather than offering the right to bail, which in individual cases creates a better balance amongst all the competing interests in a criminal justice case. Of course, most systems of preventative detention also rely heavily on pretrial services to fill the gap that the incentives for monetary bail don't exist. In other words, they replace the incentives that monetary bail and bail agents provide, including arrest powers. Those all go away under the no money bail system. And so no money bail systems are expensive because they rely on these particular alternatives, which can be electronic monitoring, home arrest, scram units, and all this type of correctional technology, the costs of which in many cases are passed on to the defendants. Can there be a hybrid model under this theory of bail incorporating preventative detention? I think so. And I think the Nevada Supreme Court recently held under federal law, I believe erroneously, but nonetheless held that after a certain period of time in detention, when a defendant cannot post their bond, the prosecution will have the burden to meet the requirements of U.S. versus Salerno. That is, to prove by clear and convincing evidence a flight risk or danger that no other conditions of release are adequate to ensure public safety or appearance in court. In other words, there cannot simply be continuing detention on an unposted bond. There's a period in time when the burden shifts to the state to prove the need for continuing detention. In other words, the Nevada Supreme Court held that probable cause is simply not enough after a certain period of time, when the bond is otherwise not excessive under the Eighth Amendment or state constitution. And all of this sort of makes sense to me. Let's allow persons to post their bail or get released on their own recognizance within a short period of time, either on a bail schedule or having seen a judge in short order in a matter of hours of being arrested. And for those who do not, after a short period of time, a heightened evidentiary burden would apply to the prosecutor to prove the need for continuing detention. And I think this is a way to increase the due process rights of defendants, to put a higher evidentiary burden on the need for detention, but to also preserve the people's rights to protect the public and guarantee the appearance of the defendant in court. Let's talk a little bit about what the Uniform Laws Commission did. This purports to be a hybrid model, but in reality, what the Uniform Law Commission is calling for is a pure system of detention or release using a general grant of preventative detention, which is undefined and which is to be defined by some legislatures at some point in the future. While the Uniform Laws Commission applied the requirements of Salerno to an unposted bail, that really is a fiction. Because why would a prosecutor seek to have a high bail that a defendant can post, go through all the exercise of proving that the defendant is too dangerous to release, that the defendant will commit a new crime, that the defendant will not appear in court, that the defendant is a threat to society, only to have a judge set a monetary bail that the defendant then posts? That's fiction, folks. So what a prosecutor would do under the Uniform Law Commission Act is seek preventative detention every time, because seeking a bail would make absolutely no sense. In this sense, the Uniform Laws Commission has decided that all jurisdictions should go to the no money bail system and use preventative detention, even though it may not be constitutional in that particular jurisdiction. You know, to go back in time and talk about what advocates against the Bail Reform Act of 1984 thought, I think is an important exercise. But I think the biggest point at the hearing that led up to the Bail Reform Act of 1984, which really went on from 1980 to 1984, was that speedy trial reform would be the most effective way to reduce the burden of pretrial detention across all defendants in all cases, in all states, in all courts. And why is that? Because if we could reduce pretrial detention by 30% by making the trials speedier, we would then reduce the amount of pretrial detention. I would point you to an example of the state of Michigan, where the Pew Charitable Trust recently studied the Michigan jail system. And of pretrial detainees, what we found is that 17% of defendants drive 82% of the jail populations. And what that means is that people who stay in jail the longest on these cases is what drives the jail population. And so the real opportunity on jail costs is speedy trial reform and shortening the amount of time of those people who are going to stay in jail, of shortening those time periods. The other thing that I think was pointed out, and is something that jurisdictions should look at, is differentiated case management. If the guy is in custody, we ought to get to that case quicker than if the guy is not, to reduce unnecessary pretrial incarceration. I would also point out that the right to bail coexisted quite well prior to this generation of mass incarceration, which by all accounts began sometime around 1970. I can argue, and I believe with all my heart, that finding ways to authorize sub rosa detention and denying the right to bail has instead been part and parcel of causing a generation of mass incarceration, not having reduced it. And certainly that's the research of Professor Worth from Rice University has shown, that this risk assessment methodology of rationing up people's risk over time and counting people as more risky and viewing people as risky has only reified our overuse of incarceration. And so attacking the right to bail and limiting the right to bail, we believe, and it is clear in the federal system, has been a reason for an increase in mass incarceration in our system. So preventative detention is not the answer. And we will fight vigorously against preventative detention policies. We don't think our country needs preventative detention, and our country didn't have preventative detention prior to 1987. To base somebody's detention on something we might think they might do in the future based on some group data risk algorithm, we just don't think is good enough. If you have questions or comments, go to our website, ambailcoalition.org, or shoot me an email at jclayton@americanbail.org. You know, in the Salerno dissent, Justice Thurgood Marshall said of the majority opinion, theirs is a decision that goes forth without authority and will come back without respect. And I would say tripling pretrial incarceration over a generation, making liberty not the norm, making detention the norm, I think he was certainly right. Thanks again for taking the time to watch this part 3 of our series. We wish you a good day.